Hello, friends. I welcome you all to this 51st session of Law of Evidence. And today, our topic will be section 119 and 120 of the Law of Evidence. In it, having a brief overview or to have a brief overview of what all we are going to study. So, first, we will see how evidence of dumb witness is to be taken. A witness who is unable to speak, how his evidence is to be taken by the court, what are the precautions to be taken in this respect, and then another question, that are a spouse competent witness. Along with it, we can make one more question, are parties competent witness? That is, if suppose there is a plaintiff, is he competent witness? If he is a defendant, if he is a competent witness? So these things we are going to study. So first of all, let us see 119. Witness unable to communicate verbally. Section 119 provides that a witness who is unable to speak may give his evidence in any manner in which he can make it intelligible. That is, if he is unable to communicate verbally, then in any manner whatsoever, by manner, only condition is that he should make it intelligible here means that the other party should be able to understand it. Now, what two manners have been specifically provided in the act itself? That is, one is that it may be provided by writing. For example, if a person is unable to speak, he may give it in writing, or by signs, as you can see in these pictures, that by sign language they are communicating with each other. But there are certain precautions to be taken and certain things to be noted. First thing is that this writing or sign, it should be made in open court. It is a part of principle of natural justice that the other party, or it should not be in a secretive manner. So it has been said that it should be in open court. Second is that this evidence shall be deemed, not really, but it should be deemed to be an oral evidence. So even if it is in writing, it will be deemed to be an oral evidence. Mind it is a very interesting feature to note that though a thing is in written, it is considered to be oral evidence. Now, the Criminal Amendment Act 2013 has provided certain guidance as to how it is to be noted down in the court. So, first is that the court should take assistance of an interpreter or a special educator in recording the statement. So, as you know, that the court judge is not a person who is expert in sign language. So, in that case, special educator or interpreter, his assistance is to be taken, and then it has to be videographed. Why videographed? So that it remains evidence. For example, we don't know what the sign means actually, and for its interpretation is possible in later phases only when it is videographed. So the Criminal Amendment Act has provided that it has to be videographed, and assistance of interpreter or a special educator should be taken in this regard. Next is section 120, which says whether parties and spouse, that is wife and husband, whether they are competent witness or not. So it has two part, first part and second part. What it says is that in civil proceedings, the parties to the suit are competent witness. So if he is defendant or he is plaintiff, they are competent witness. And second, and their spouse, that is husband and wife, defendant and his wife, or if he is female, then husband. So their spouses are also competent witness. Similarly, in criminal proceeding, it is said that a spouse, that is husband and wife, are competent witness. This is given under section 120. Why it is specifically mentioned that whether husband and wife are competent witness or not? In olden days, there was concept that husband and wife were one person in law. You must have had heard about the concept of Ardhanarishwar. So, husband and wife, where Lord Shiva and Parvati ji are considered to be one unity. So, similarly, earlier also, the law considered them to be one person. That thing has now changed, and it says that the spouses are competent witness in civil proceeding, the spouses are competent witness in criminal proceeding also. However, there are certain privileges which we will talk later on, but as such, they are competent witness. Just let us just revise what all we did. First, we did section 119, where it says that if a witness is unable to communicate verbally, then he can communicate in any manner to make him. Only thing is that he should make himself intelligible. It can be in writing, it can be in sign. It has to be in open court. It shall be deemed to be an oral evidence. Assistance of a special educator or interpreter should be taken. Videographing should be done. Then section 120 provides that parties in civil suits are competent witness. Spouses of the parties are also competent witness. In criminal proceedings, the spouses are also competent witness. That's all. Thank you, friends.